Owners of the Cleveland Browns have updated their federal lawsuit again related to their hopes to move their football team to Brook Park. Legally speaking, this doesn't really change what they're trying to do, which is get the Modell Law declared both unconstitutional and irrelevant to their plans. But it does add a lot more detail to their claim, including citing the Browns' years-long efforts and multi-million-dollar investment in lakefront development plans that the Haslams argue the city failed to act on. This is all in support of their request for a federal court order preventing the city of Cleveland from attempting to enforce the Modell Law against them. As a reminder, the Modell Law says the owner of a pro sports team that plays most of its home games in a facility that uses taxpayer money for upkeep cannot relocate without giving at least 6 months' notice and also allowing others the opportunity to bid to keep the team where it currently is. What the Haslams have done here now is challenge the Modell Law more specifically than they initially did, saying it violates the U.S. Constitution and providing the federal law that would allow the court to rule on the case, while also alternatively continuing to argue that moving the team from downtown Cleveland to Brook Park doesn't trigger the Modell Law. This latest update also adds more parties to the federal lawsuit, including 3 new business entities as plaintiffs and individually naming Cleveland City Law Director Mark Griffin as a defendant in his official capacity alongside the city of Cleveland. This is separate from the lawsuit filed by the city of Cleveland in Cuyahoga County, which is seeking to enforce the law that the Haslams want declared unenforceable, both in general and specifically as it relates to them. I asked Ohio Attorney General Dave Yost for comment on the updated version of the federal lawsuit and didn't immediately hear back. This is Stephanie Haney, legally speaking, for 3 News.